The courthouse steps are empty except for the two of us. Afternoon light cuts across the cold stone. Renata Ashford, bar examiner, senior partner. The most composed woman I have ever known is standing 2 feet from me, and something in her face is not composed at all. She says, "Passing you cost me something. I am not going to make it smaller than it was." I don't move. I can't. She examined me on the ethics of disclosure. Sat through 113 minutes of it, 3 feet from the person she has never stopped loving. She doesn't ask for anything. She just lets me see it. And I have absolutely no idea how we ended up here. If you want to hear uncensored, too hot for YouTube stories, check out my Patreon in the description, tell us where you are watching from, and subscribe. The room was the size of a good idea. Small enough that every breath counted, large enough that the distance between the applicant's chair and the examination panel felt constructed, deliberate, institutional, designed to remind you of exactly what you were, and exactly what they were, and why those two things were not yet the same. There was a pitcher of water on the table that no one had touched. A legal pad in front of each examiner with clean, blank lines. 3 pens, 3 faces arranged in the particular composure of people who did this regularly and had long since stopped performing it. Judge Clement Farrow, on the left, was 72 years old, and had the comfortable authority of a man who had made every significant decision of his career at least once before, and found none of them particularly surprising. He was reading something in my file. He did not look up when I came in. Patricia Solis, in the center, was a senior partner at a mediation firm I recognized from its downtown address and its reputation for taking the cases no one else would. She gave me a brief, professional nod when I sat down. The kind of nod that means I see you and reserves judgment. Renata Ashford was on the right. She did not nod. She was wearing a dark suit, the color of old ink, not black, not navy, the specific shade between them that some women learn to wear when they want to be taken seriously and do not want to be visible as having tried. Her hair was pinned with the efficiency of someone who had made the gesture automatic. She had a pen in her hand, uncapped, held the way attorneys hold pens at depositions, not for taking notes, for having something to hold that keeps the hand from doing what the hand might otherwise want to do. I had not seen her in 9 years. She looked exactly the same, and entirely different, which is the thing that happens to people when the architecture is the same, but the weight inside it has changed. The precision was familiar. The stillness was familiar. The way she occupied her chair fully, without wasted energy, like every part of her was doing exactly what it was supposed to do, and nothing else that was familiar. The way she was not looking at me. That was new. Or rather, the way she was looking at me and managing to look at me the way she might look at any applicant. Like I was the next item in a long professional afternoon. Like the library carol and the third floor and the word forever were artifacts from a jurisdiction she no longer practiced in. I sat down. I folded my hands on the table the way my advisor had told me to, neither gripping nor limp, just present, professional, the physical language of someone who is prepared and not frightened. I was prepared. I was also frightened. I was holding both of those truths in my chest, and not letting either of them reach my face, which is the only skill that matters in a room like this one. The coordinator had handed me my materials at the door, a sealed packet, the problem I would be arguing, 60 minutes of preparation time that had apparently already passed, even though it also felt like it was still happening somewhere in my body. He had said quietly that the panel had reviewed my written submissions and found no procedural irregularities. I had thanked him. He had not known that one of the examiners in this room had once pressed her mouth to the back of my neck in the reading room of our law school library and told me she could not keep doing this, and I had said, "Then don't stop," and she had not stopped for 7 months after. That was not in my written submission. It was not relevant to the examination. It was relevant to the specific composition of my heartbeat right now, but the examination did not ask about heartbeats. "Good morning, Miss Vega," Judge Farrow said. "We appreciate your patience with the scheduling delay." I thanked the panel. My voice was steady. I had practiced this. "We'll begin with your prepared argument," Patricia Solis said. "You have reviewed the problem?" I had. The problem was a professional responsibility scenario, an attorney who had discovered, mid-case, that her client had been misrepresenting a material fact for months. The question was what the attorney was obligated to do, what she was permitted to do, and where the line between disclosure and privilege sat when the client refused to cooperate. Professional responsibility. The ethics of what you owe the people who trust you. I looked at the problem statement, and then at the panel, and then, for one unguarded half-second, at Renata. She was looking at the middle distance, slightly left of my face. Her pen was still. The jaw was set, not flexing yet. That would come later, just set. Like someone who had made a decision and was living inside it. I began my argument. The first 12 minutes went the way I had prepared. I walked through the professional responsibility framework with the systematic clarity bar. Examiners expect the rule, the application, the exceptions, the policy rationale, the competing considerations that sit at the edge of any scenario where duty to client and duty to court press in opposite directions. Judge Farrow asked 2 clarifying questions that were genuinely clarifying, and I answered them directly. Patricia Solis challenged my reading of a specific ethics opinion from the State Bar, and I disagreed with her, politely and precisely, which produced a brief nod I chose to interpret as professional respect rather than surprise. Renata said nothing for 12 minutes. When she finally spoke, her voice was what I remembered. Not louder or softer than memory, not differently pitched, not altered in the ways that time alters things when you have nothing to compare memory to except itself. Just her voice, the same precision, the same economy. Words used like tools rather than decorations. Miss Vega, she said. In the scenario, the attorney discovers the client's misrepresentation during deposition preparation, not during the deposition itself. Walk me through why that timing matters to your analysis. I looked at her. She looked at the legal pad in front of her. The timing matters, I said, because the attorney's obligations under Rule 3.3 are triggered differently depending on the stage of proceedings. If the misrepresentation has not yet entered the record, if it exists only in the attorney-client communications up to this point, the attorney has more options available than she would have once the false evidence has been presented to the court. She wrote something. I could not tell what. And the options, Renata said. Name them. She was looking at me now, directly. The professional attention that was absolute and disclosed nothing. The attorney can withdraw from the representation, I said. She can counsel the client to correct the record voluntarily. She can seek guidance from the ethics hotline without waiving privilege over the specifics. She cannot, under the rules, knowingly allow the false evidence to be used or presented in any form. Renata said. And if the client refuses to correct the record? I said. Then the attorney must withdraw. There is no option that permits her to remain in the representation while the misrepresentation stands. Renata said. And if withdrawal would itself damage the client's case if the timing signals to opposing counsel that something has gone wrong? I said. Damage to the client's case is not a sufficient reason to allow false evidence. The duty to the court supersedes the duty to the individual client in this specific instance. The rules are explicit. The attorney does not have discretion to decide that the client's interests outweigh the court's integrity. A pause. She made another note. She said, You sound certain. I said, The rule is clear. She said, The rule is clear. The situations in which it must be applied rarely are. I said, That's why the rule exists. To give attorneys a fixed point to return to when the situation makes everything feel uncertain. A brief silence. Something crossed the room that wasn't about professional responsibility. Judge Farrow moved to the next topic, and we moved with it, and I spent the next 15 minutes talking about application standards, while being entirely aware that Renata had set her pen down and was looking at the table with the specific stillness of someone who has heard something in a professional exchange that was not meant for the professional exchange. She picked up the pen again at the 20-minute mark and resumed her notes as if nothing had happened. Because, for the record, nothing had. The record would show a clean oral examination conducted by 3 competent examiners on a late April morning. The record would not show what I knew, that the woman on the right had used my name once, at the opening of her first question, and had not used it again, and that the withholding of a name across 113 minutes was more charged than anything the record was capable of capturing. What she did in that examination room was the most precise and demanding thing I had experienced in any oral context. She was not making it harder because of our history, I was certain of that, in the way you become certain of things that are not comforting but are accurate. She was demanding because that was what she did. Because Renata Ashford had always understood that the purpose of an examination was not to catch someone failing but to locate the exact boundaries of what they knew, to find the edge of the argument and press on it, not to break it, but to establish how far it extended and whether the person arguing it had built it to last. She asked 11 questions over 73 minutes, each one designed to find the boundary I had not fully accounted for. Each one requiring me to commit to a position and defend it against her specific and entirely accurate counter-reading of the material. She was the best examiner in the room. She was also watching me the way you watch something you are trying not to react to. I know what that looks like. I have studied it in mirrors. The second segment was 40 minutes of evidentiary standards and attorney-client privilege in corporate representations. She asked about the crime-fraud exception. Specifically, at what point an attorney's knowledge of a client's intended future wrongdoing overrides the privilege? I said, the exception applies when the client seeks the attorney's assistance in furtherance of the fraud. The attorney's mere knowledge is not sufficient. The assistance is what matters, she said. And if the assistance was given in good faith before the attorney understood the full context? I said, good faith is relevant to the attorney's culpability in a disciplinary or malpractice context. It is not relevant to the crime-fraud exception itself. The exception exists to protect third parties from ongoing harm. It is not an evaluation of the attorney's intentions or state of mind, she said. So an attorney who acted entirely in good faith may still have participated in something that strips the privilege. I said, yes, that is the correct reading, she said. And how should that attorney proceed when she finally understands what has happened? I said, she discloses. She corrects the record where possible. She accepts whatever review that correction triggers. She does not construct a justification for remaining silent because the cost of disclosure feels too high. The room absorbed that. Judge Farrow shifted slightly in his chair. Renata said nothing for the remainder of the segment. In the final 10 minutes, she wrote steadily. Her handwriting, visible from my angle, was architectural precise, nothing decorative, the kind of writing that says everything it needs to say and nothing extra. I had read that handwriting in the margins of casebooks 9 years ago. She had left notes in pencil because she said pencil was honest and pen was performing permanence. I looked away from her handwriting. The examination ended. Thank you, Miss Vega, Judge Farrow said. We'll notify your admissions contact within 5 business days. Patricia Solis said. You argued the professional responsibility question well. That's a genuinely difficult problem. Renata said nothing. I thanked the panel. I collected my materials. I walked to the door. Behind me, I heard the sound of a pen set down on a table. Not a drop. A set down, deliberate, complete. The sound of someone who has finished one thing and is not yet starting the next. I counted the silence. Half a second. 1 second. I did not turn around. I went into the hallway and did not let my breath go until the door clicked shut behind me. Dessa Lim arrived at the 4-minute mark. She came around the corner from the elevator bank carrying 2 coffees and the specific expression of someone who knew something she had not said and was weighing whether this was the moment. I knew Dessa from the first iteration of law school, the first 18 months, before my mother's diagnosis, before I left. She had finished on schedule, practiced corporate law for 2 years, pivoted to civil rights, and now ran a small plaintiff's firm 3 blocks from the courthouse I could see through the window at the end of this hallway. She also knew Renata. They had overlapped for years in bar association contexts, committee work, dinners, the specific close-knit geography of a legal community in a city this size. She handed me the coffee without asking. She sat in the second chair. She said, "How was it?" "Fine," I said. She said, "How was she?" I said nothing. Dessa tilted her head and looked at me with the quiet attention of someone who had known me in my previous life and had accumulated enough data points to know what fine meant when I said it in this particular register. She said, She asked about you. About a year after you left the first time. Just once, and it was under the cover of asking about the program generally who had taken medical leave, who was expected to return. But I knew which name she was searching for, and I told her you were okay, because that was the honest thing I had that was also useful to give her. She also applied for the bar examiner committee 8 months after you left. She told me once that she had found the work useful, that it gave her something to hold on to that was about the law, and not about the year she had just had. I'm not telling you this to assign meaning. I'm telling you so you understand what you walked into today, and what the examination cost her to conduct. I stared at the carpet runner. She had asked, once, undercover, because asking directly was not something Renata Ashford did when the asking would reveal something she had decided not to reveal. I said, "Thank you for telling me that." Dessa said, "I'm telling you now because you are about to go back in there, and I want you to know that whatever she is holding in that room with you, it is not indifference. I cannot tell you exactly what it is, but it is not that." The examination room door opened. The coordinator leaned out and said, "Miss Vega, the panel is ready for the follow-up segment." I stood. I picked up my coffee, took one sip, set it on the chair. Dessa said, quietly, as I walked toward the door, "You know what you're doing in there?" I said, "I know the law." She said, "I meant the other thing." I did not answer that. I went back in. Let me tell you who Renata Ashford was at 24, because who she was at 24 is the foundation of everything that came after, and the frame inside which everything today was contained. We met in the first week of law school orientation. We ended up at the same table for the ethics session, 40 minutes of a senior faculty member explaining, with the loving patience that conceals professional dread, that we would spend our careers making consequential decisions in situations where the right answer was not obvious and the wrong answer had not been made illegal. Renata asked a question about the conflict between duty to client and duty to court. It was the most precise question asked that morning. The faculty member said, "You've read ahead." She said, "I read the assignments." It was not ambition. It was the particular relationship with the material that some people have from the beginning, and that others spend years trying to develop. I had looked at her across the table for 3 more seconds than the moment required. That was how it started. It continued in the library. The 3rd floor had a carrel section at the far end, narrow wooden compartments that created the impression of privacy without actually providing it. We both tended to study there. We both tended to study late. We discovered, sometime in October, that we shared an understanding of late, not midnight, but the specific hours between midnight and 3 when the building had emptied of everyone except the committed, and the people who had found that the empty hours were the easiest ones in which to be honest. She did not just know the rules. She understood what the rules were trying to do. The gap between those two things is enormous, and most people spend years closing it, and Renata understood it from the beginning in a way that looked effortless and was, I would later understand, the product of a discipline she had been building since she was young enough to know that discipline was a form of protection. We had dinner 3 times in October, before we admitted the dinners were happening on purpose. We were both tired of the covering story by December. She said, on a Thursday night in the carrel with a constitutional law outline open between us that neither of us had been reading for 40 minutes. "I would like to stop managing this." I said, "This?" She said, "Yes, whatever you think I mean by that." I said, "I think you mean what I mean." She said, "I think I do too." I said, "Okay." She said, "Is that your answer?" I said, "It's my opening argument." She looked at me for a long moment, then she smiled, a real one, not the managed professional warmth she deployed in seminar rooms, but a genuinely amused and slightly undone smile that told me what Renata Ashford looked like when she stopped performing composure. She looked like herself. She looked like the most specific person I had ever been in a room, with the kind of specific that does not fade when you are not looking at it. We were together for 18 months. The best 18 months of my professional and personal life, woven together so completely I could not locate the seam. She would graduate in the spring. I had 2 years remaining. We planned around the distance, built toward something that required patience and specificity, and the belief that what you are building is worth the work. She said forever in April. We were on the roof of her apartment building. The city spread below us in the way cities look at night, when you are with the right person, less infinite, more specific. She said it looking at the city, not looking at me, which was how she said the things that mattered most. Giving you the option of not having heard it if having heard it was too much. I heard it. I said it back. She looked at me then, relief and recognition, in that specific order, in the space of half a second. I promised forever on a roof in April, and I believed it completely. I believed it the way you believe things when you have not yet learned what happens when the ground shifts under a promise. My mother was diagnosed in September. Non-Hodgkin's lymphoma, 3rd stage, found by accident. The oncologist used words like aggressive and early intervention, and I sat in a hospital chair and heard all of the words and none of them. I told Renata in pieces. Too carefully, with too many qualifications, trying to manage the edges of the information so the center would land easier. She listened. She said, "What do you need?" I said, "Time." She said, "I'm here." What I did not say, the word aggressive translated, in my private arithmetic, to something that made the next 2 years of law school feel like a luxury I could not justify alongside care schedules and geographic distance, and the specific impossibility of being a full-time student in one city, while a parent is, in treatment, in another. I told myself I would tell her when I knew more. I knew more in 3 weeks and still did not tell her. I left in October. The conversation was insufficient. She held my face in both hands in the doorway of her apartment at 6 in the morning and said, "I'll be here." I called twice. The second call, I was in a clinic waiting room and I could hear in Renata's voice that she had been holding herself carefully for weeks and I was the reason, and the knowledge of it cracked something in me I could not repair at that moment. I said I would call. I did not call. The silence accumulated the way silences do when they are not chosen but not interrupted each day, making the next day harder, until I was living in a silence I had not designed and could not exit. She stopped calling after the 6th attempt. My mother died 3 years into the diagnosis. I finished law school part-time, passed the written bar on the first attempt. Moved back to this city because it was where I had always intended to practice, and because, if I was honest, because Renata Ashford was here and had built something here in the years I had been absent, and I wanted to be in the same world as the person I had promised forever to and failed to stay for. I had not expected it to produce a bar examination panel. There was a bar association reception that evening. I had planned to skip it. Then I received the examination schedule and recognized the third name on the panel, and I decided that not attending was itself a choice, that staying away from the first professional space I would share with Renata was choosing absence again. I had been choosing absence for 9 years. I was tired of it. Dessa was near the wine table when I arrived. She handed me a glass. She said, "She's here, left side of the room." I did not look left. I took a sip, looked at the far wall, and let myself think for a moment. Then I looked. Renata was across the room, half-turned from the admissions chair, her wine glass held at a height that suggested she had forgotten she was holding it. She was not looking at me directly. She was looking at the space adjacent to me with the careful attention of someone who has decided that looking directly is not something she is going to do and is finding the workaround insufficient. The suit was still the dark ink shade, the hair still pinned, the composure still present but visible, for the first time, as the effort it was. I crossed the room. She turned to face me when I was 2 feet from her. Her expression was the composed version, every line deliberate. She said, "Miss Vega." I said, "Renata." A half second. Something crossed her face that was not the managed version. The admissions chair had drifted away with the social instinct of someone who has learned to recognize when a conversation is not for him. She said, "You argued the professional responsibility question well this morning." I said, "Thank you." She said, "The crime-fraud analysis in the second segment was less prepared. You were working through it in real time." I said, "Yes." She said, "It didn't affect the quality of the conclusion. The reasoning was correct even when the path to it was visible." I said, "Is that a critique or an assessment?" She said, "Both." I held her gaze. She held mine. The room moved around us in the way rooms move when two people are having a different conversation than the one visible to anyone else. I said, "Can I ask you something?" Her jaw set. Slightly. The millimeter I had catalogued in the examination room. She said, "This context isn't appropriate for a conversation between an applicant and a member of the examining panel." I said, "I know. I'm asking anyway." She set her wine glass on the table beside her, both hands free, the pen holding hand, with nothing to hold. She said, "Ask." I said, "The examination, today. I need to know whether the panel's review of my performance is affected by the fact that you were on it, not as a challenge, as a factual question. Because if there is a conflict that should have been disclosed and managed, the appropriate thing is to say so now." She said, "There is no conflict in the review." I said, "Renata." She said, "The panel's assessment is based on your performance. Nothing else entered the evaluation." I said, "I'm not asking about your professionalism. I'm asking whether it cost you something to be in that room." The longest silence of the day. She said, "That is not an appropriate question for this setting." I said, "I know." I said, "I'm not asking you to comment appropriately, I'm asking you to say something true." She looked at me. For 1 second, underneath the dark suit, and the pinned hair, and the 9 years of professional distance, she looked at me. She said, "It was a significant examination day." I said, "Yes." She turned to leave. At the edge of turning, she stopped. She said, to the space slightly left of directly at me, "The exception piece, you worked it correctly, in the end. Good faith is not the standard. The disclosure obligation is not contingent on intent. You knew that." I said, "I know it now." She said nothing else, and walked away, and I stood holding my glass and understood that she had just told me something that was not about the examination. She had wrapped it in the examination so she could say it. Good faith is not sufficient. The disclosure obligation is not contingent on intent. I was putting my coat on in the corridor when I heard footsteps behind me. I turned. Renata was in the corridor, coat over her arm, bag on her shoulder, and she looked for one stripped-back second like the woman from the library carol rather than the examiner from the conference room. Not more vulnerable, just less armored. She said, "The elevator is slow at this hour." I said, "I know." She said, "Are you well?" "In general, not today specifically." I said, "Yes, I'm well in general." She said. I said, "She died. 3 years into the diagnosis, she was at home. It was as peaceful as it was going to be." Renata's jaw moved. Not the professional set. Something below that, something that said this information was landing somewhere it was going to stay. She said, "I'm sorry. I didn't know the full extent of it when you left." I said, "I know you didn't. That was my failure. I should have told you all of it instead of the version I thought I could manage." She said. I interpreted the silence as. I said, "I know what you interpreted it as. I understand exactly why. The silence was not what you thought it was, but I produced it, and the producing was mine." She said, "I am not going to have this conversation in this corridor." I said, "I know. I'm not asking for tonight. I'm asking you to know one thing, that I came back to this city because it was where I was supposed to be. That being in that room with you today was significant in ways that have nothing to do with the examination outcome. That's all." She looked at me. The elevator arrived. The doors opened. The corridor was empty, except for the two of us. She said, "Miss Vega." I said, "Rowan." A half second. She said, quietly, in the voice that was not the examiner's voice, smaller, specific, present tense. "I know." She walked to the elevator. She stepped in. She turned around. She did not look at me. The doors closed. I stood in the corridor holding my coat and the specific weight of 2 words and tried to understand how 2 words could constitute both the smallest possible admission and the most precise thing she could have said. I know. Not I knew then. Not I remember. I know. Present tense. Living inside it now. Still holding it? Whatever it is. In whatever shape, 9 years of professional distance and deliberate management have made it. I stood there until another elevator arrived, then I went down to the lobby and out into the April city, and did not try to name what I was feeling, because the thing I was feeling did not have a single name. It had 2 words, present tense, the only currency that had ever meant anything between the two of us. I know. It was more than enough to stay awake with. The results arrived on a Thursday. 5 business days, Judge Farrow had said, and 5 business days was what it took. My admissions contact sent the notification at 9:14 in the morning, and I was standing in the kitchen of my apartment holding a coffee mug I had not yet managed to drink from, when my phone lit up with the subject line, Bar Admission Examination Result, Vega, Rowan M. I set the mug down. I opened it. The panel had completed its evaluation and found no deficiencies in the applicant's performance or character review. Admission to the bar would be formally conferred at the scheduled swearing-in ceremony on the 2nd Friday of May. I read it twice, then I set my phone face down on the counter and stood in the kitchen for a while. I had passed. The examination had been conducted by 3 examiners, one of whom was Renata Ashford, and the panel had assessed my performance on its merits and found it sufficient, and I was going to be admitted to the bar in 11 days. The thing about passing is that it does not resolve anything except the thing it was designed to resolve. I had spent the 5 waiting days with a practice discipline work, preparation for the firm I was joining, the procedural business of transitioning from applicant to attorney. I had not called Renata. I had not messaged her. I had held the 2 words she had said in the corridor with the care of someone carrying something that does not belong in a pocket but has nowhere else to go, and I had carried them through 5 days of not knowing the outcome, and now I knew the outcome, and the 2 words were still there, unchanged. Dessa called at 9:23. She said, "You passed." I said, "You saw." She said, "I have the list. Don't ask me how. Congratulations, counselor." She said, "How do you feel?" I said, "Like I need to think about what comes next." She said, "I know what comes next. I'm having a small dinner, next week, before the swearing in. You, me, 2 people from the old program who finished around the time you did. Nothing formal." I said, "Is she invited?" A pause. Dessa said, "I haven't decided yet. I was going to decide after I talked to you." I said, "Invite her." She said, "You're sure?" I said, "We are going to be in the same professional world for the next 30 years. I would rather begin that with honesty than continue with management." Dessa said, "That is the most lawyerly way anyone has ever told me to do something terrifying." She invited her. Renata said she would come if her schedule permitted, which Dessa interpreted as a yes, and which I interpreted the same way, and which neither of us said out loud, because saying it out loud would have required us to acknowledge that we were both treating the attendance of one specific attorney, at a small dinner, as a more significant event than it had any professional right to be. The dinner was on a Wednesday evening in the private room of a restaurant Dessa used for events. She wanted to feel both professional and human. 6 people around a table, me, Dessa, 2 other attorneys I had known in the first iteration of law school, a civil rights colleague of Dessa's, and, at the far end of the table, Renata. She arrived last. She was in dark pants and a silk blouse the color of slate, and her hair was down. I had known, from 9 years of memory and 5 days of knowing she was in this city, that seeing her without the formal armor would be different. I had not known it would be different in that specific way, not more vulnerable, not softer, just more present. Like the version of herself she wore in professional contexts was a decision she made every morning, and the version she wore now was what the decision was protecting. She did not look at me for the first 20 minutes. The dinner moved through cases and bar politics and the specific comedy of legal practice that only attorneys can produce from their own professional suffering. I talked about the firm I was joining, a mid-size plaintiff's practice with a civil litigation focus. Someone asked about my area of focus. I said employment discrimination. Dessa said, with an emphasis on institutional accountability, if I know Rowan. I said, that's accurate. At the far end of the table, Renata looked at the middle distance briefly. Then she said, to the table generally, the firm has a strong record in that space. Good choice. It was the first thing she had said that was addressed even approximately to me. After dinner, in the brief reconfiguration of people that happens when a meal ends and no one is quite ready to leave, I found myself standing near the window while Dessa managed the bill with the decisive authority of a woman who had made her peace with paying for things she organized. Renata was 2 feet to my left, looking at the street through the window. She said, without turning, "Congratulations on the result." I said, "Thank you." She said, "You argued well. The result reflects the argument." I said, "Is that something you would have said to any applicant?" A pause. She said, "Yes. And I would have meant it for any applicant. I also mean it specifically for you." I said, "That's a careful answer." She said, "I am a careful person." She turned. The window light was doing something honest to her face, not flattering, just direct. I said, "I'm going to be in this city now. In this bar. We are going to be in the same rooms for a long time." She said, "I know." I said, "I need you to know that I am not interested in managing that. I'm not interested in spending the next 30 years exchanging professional pleasantries across bar association rooms and pretending the 9 years are a scheduling matter." She said nothing. I said, "I'm not asking for a resolution tonight. I'm telling you that I came back and I intend to stay, and I intend to be honest about what that means." She looked at the street. She said, "I will need time." I said, "I know that too." She said, "Not because I don't." She stopped, started again. "Not because the conversation is unwelcome." I said, "I know." Dessa appeared at my shoulder with the timing of someone who had been watching the window from across the room. Renata said goodnight to the table. At the door she paused for approximately 1 second, which was not directed at anyone in particular, and also unmistakably directed at me. Then she left. I stood at the window and held what she had said and what she had stopped herself from saying, and tried to decide what to do with the sentence that had ended before it was finished. Not because I don't. The admission to the bar was conferred on a Friday morning in the ceremonial courtroom on the 3rd floor of the courthouse. 31 attorneys recited the oath in unison, 31 people saying the same words at the same time in a courtroom. And the words are not performative, they are the thing itself. The moment the thing becomes real. Dessa was in the gallery. She was crying, which she would later deny. I did not look for Renata. She was not on the admissions committee for this ceremony. There was no professional reason for her to be there. She was there. I saw her at the back of the gallery when we stood for the oath. She was in the dark suit, standing against the wall with the composed professional expression she wore to every room. She was watching the front of the courtroom. I recited the oath. I shook the judge's hand. I accepted the certificate. I did not look at the back of the gallery again. When we filed out, she was gone. But she had been there. She had come to a bar admission ceremony for a person she had examined, which was unusual enough to be noticed, and specific enough to require an explanation that was not professional, and she had not asked me whether she could come. She had come anyway. That was information. The first time we were in the same professional room as peers, not examiner and examinee, was a Bar Association Ethics Committee meeting 6 weeks into my practice. Marchetti and Webb had put me on the committee as a junior member. The committee reviewed proposed ethics, opinions, and met on the 3rd Tuesday of every month in the Bar Association conference room on the 14th floor. The 14th floor. The same gray carpet. The same institutional lighting. I walked in on the 3rd Tuesday of June, and Renata was already seated on the far side of the conference table. She looked up when I came in. Her expression did not change. The meeting lasted 2 hours. On the second proposed opinion, a question about an attorney's obligations, when she discovers mid-representation that her client has materially misled her, Renata and I were on opposite sides of the threshold. Question. She argued that the attorney's obligation to withdraw kicked in at the point of confirmed knowledge. I argued that the reasonable suspicion standard was more protective of third parties and better aligned with the spirit of the rule. She said, "The spirit of the rule is less legally actionable than the letter of it." I said, "The spirit is what the letter is trying to do. Enforcing the letter while ignoring the spirit produces outcomes the rule was designed to prevent." She said, "You're importing purpose into a text that is capable of supporting both readings." I said, I'm applying the interpretive framework the ethics board itself uses in its advisory opinions. She looked at me. I looked at her. The committee chair looked at both of us with the patient attention of someone watching a weather system develop. He said, "Both positions have merit. We'll table the threshold question for the next meeting." Afterward, in the hallway outside the conference room, I was putting my materials in my bag when she appeared at my shoulder. She said, "The reasonable suspicion argument is stronger than you made it." I said, "I know." I was calibrating to what the room could hear. She said, "Don't do that." I said, "Don't calibrate?" She said, "Don't make yourself smaller in rooms where you should be full-sized." I looked at her. She looked at the elevator. She said, "The argument you didn't make, the one about the cost to third parties when the attorney waits for confirmation, would have changed the room." I said, "I'll make it next month." She said, "Good." She went to the elevator and I watched her go and thought about being told not to make myself smaller by the woman who had used my name once in 113 minutes. Which was itself a form of making me smaller, or had been then. And which was something different now, not the same gesture in reverse, but something new, the correction of someone who wanted to see the full-sized version. The pattern that developed over the following weeks was not dramatic. It was the specific accumulation of proximity that happens when two people exist in the same professional world, and neither of them is actively avoiding the other. Ethics committee meetings, on the third Tuesday. Occasional bar events. The specific geography of a legal community in a city this size, which meant that attorneys who moved in similar circles saw each other regularly and were professional about it, and, sometimes, were something else about it in the hallways after. She brought the argument I hadn't made to the next committee meeting herself. She framed it as an alternative reading she had encountered in the intervening weeks, which was technically accurate. The room found it persuasive. The threshold question was resolved in a direction closer to my original position than hers. There was a continuing education lecture in July evidence law, a speaker who had clerked for the circuit. Renata mentioned it in the hallway after the committee meeting. Precise, brief. The speaker is good. The work on hearsay exceptions is unusually clear. She did not say, "Are you attending?" She did not have to. I was there. She was 2 rows ahead. At the break we ended up at the coffee station at the same time, and she looked at the program I had been annotating in the margins and said, "Old habit." And I said, "You borrowed the books I returned from the library because you said the annotations were useful." And she looked at the coffee in her hand and said, "Several times," and the room was warm and ordinary around us, and neither of us moved to make it smaller. The breaking point, when it came, was not dramatic. It happened on a Tuesday afternoon in late July, outside the courthouse on the front steps, in the unremarkable way that significant things often happen without staging, without an audience primed for it. I had been in court all morning on a discovery dispute that had resolved in our favor, but not cleanly. The kind of outcome that leaves you professionally satisfied and personally exhausted because you have spent 4 hours in a small room with opposing counsel who approaches litigation with the specific pleasure of making the process as expensive as possible for everyone involved. I came down the courthouse steps in the afternoon light, and Renata was at the bottom. She was there on her own business, a client consultation in the clerk's office. She had a file under her arm, and she was checking her phone, and she looked up when I came down the steps, and for 1 second, neither of us had time to arrange anything. She just looked at me. I just looked at her. 1 second of 2 people looking at each other before either of them had produced the professional version of themselves. Then she said, "How did the motion go?" I said, "We won. Not cleanly." She said, "Opposing counsel?" I said, "The kind who makes winning feel like losing." We walked down to the pavement and stood in the afternoon light, and I thought about the 4 hours and the specific fatigue of a morning spent being professionally precise when what you wanted to do was say the accurate thing directly, instead of the tactical thing carefully. I said, "Can I ask you something?" She said, "Yes." I said, "The examination. The bar exam, oral in April. When you said it was a significant examination day, what did significant mean?" She held the file. She looked at the courthouse steps. She looked at the street. She said, "It meant that I conducted the most professionally demanding examination of my career that morning." I said, "More demanding than usual?" She said, "Yes." I said, "Why?" A long pause. A courier passed on the pavement. A man walking fast with a phone to his ear. She said, "Because I was examining someone whose arguments I already knew the shape of, whose specific intelligence I had been familiar with for 9 years. And because conducting that examination required me to be two things at once, a fair and rigorous examiner, and a person managing something that had nothing to do with the examination, and doing both well in the same room for 113 minutes was the most costly professional performance I have given since I began this work." I said nothing. I let it land. She said, "You passed because you were correct. Your argument was sound and your analysis was complete, and the panel's assessment was not affected by my personal knowledge of you. I want to be clear about that." I said, "I know." She said, "But I also want to be clear, and I am going to say this once, and I am not going to dress it in professional language that passing you cost me something that I am not going to make smaller than it was." I said, "Tell me what it cost." She looked at me. She said, "It cost me the version of the day where I was only an examiner, where I could sit in that room and evaluate your work and not spend every question aware of every specific way you argue that I first learned in a library at 2 in the morning 9 years ago. Where I could hear you talk about the ethics of disclosure without feeling the weight of everything that has not been disclosed between us. Where I could set my pen down at the end and walk out of the building without standing in the corridor for 6 minutes before I called the elevator because I didn't know how to start walking." I said, "You stood in the corridor for 6 minutes." She said, "I counted." I looked at her, this precise, composed, deliberately managed woman who had spent 9 years building a professional architecture that could contain everything the two of us had been and had not finished being, standing on courthouse steps in afternoon light, telling me she had stood in a corridor for 6 minutes and counted them. I said, "Renata?" She said, "Yes." I said, "I need you to hear something." She waited. I said, "I came back to this city for the law. The work is real, and the reasons I'm here are real, and I would have come back regardless. But I also came back because you are here. And I have been managing that the same way you have been managing the other thing, by putting it inside the professional container and calling it something reasonable. And I am tired of calling it something reasonable." She said, "What would you call it instead?" I said, "The truth. The version where I left 9 years ago, not because I chose to, but because I didn't know how to hold both things at once. My mother's illness and you, and I chose the one that I believed would survive the absence. And I was wrong about which one that was. And I came back because I wanted to be in the same city as the person I made that mistake about and try, with whatever we have left of honesty, to do better." She was very still. She said, "That is the most complete thing you have said to me since the examination." I said, "I know. I'm done giving you the managed version." She said, "I reported a potential conflict of interest to the admissions committee chair last week." I stared at her. She said, "Not because the examination was compromised, it wasn't. But holding that line for 113 minutes, while not having disclosed the potential conflict beforehand, was something I should not have done." The chair reviewed the circumstances. The examination result stands. But the disclosure should have been made before the examination, and I failed to make it. I said, "What happens to you?" She said, "A note in the file. A conversation with the committee. Nothing that affects my standing, because the result was not compromised. But the note is there, and it is accurate, and I wanted it there, because I am done letting the professional architecture hold something it was not designed to hold." I said, "You reported yourself." She said, "Yes." I said, "When?" She said, "Last Monday. 3 days after I stood in the corridor for 6 minutes. I held that. She had gone home on Monday morning and picked up the phone and told the admissions committee chair that she should have disclosed a prior personal relationship with an applicant before serving on that panel, and that she had not disclosed it, and that she was disclosing it now. Without asking me, without warning me, without constructing the version of accountability that would be easier to live with. I said, "Thank you." She said, "I did not do it for you." I said, "I know. That's why I'm thanking you." She looked at me for a long moment in the afternoon light. Then she said, "I have a client appointment at 3. I said, "Okay." She started to go. She stopped. She said, without turning, "The roof. In April. 14 years ago. I still remember exactly what the city looked like." I said, "Me too." She went up the steps and into the courthouse, and I stood on the pavement until the door closed behind her, and then I stood there a while longer, holding the afternoon and the specific weight of me too, which was not the same as I know. It was more than I know. It was a concession of something she had been holding for 9 years and had not, until this moment, decided to stop holding. She called on Thursday. She said, "I said I would call." I said, "You did." She said, "I would like to have coffee. Not a bar event, not a committee meeting. Coffee, without professional context." I said, "When?" She said, "Saturday morning. There is a place on Clement Street that opens early. I'll be there at 8. I said, "I'll be there at 8. I was at Clement Street at 7:53 because I am constitutionally incapable of being late to anything I am nervous about, and I had been standing outside for 6 minutes when she arrived at 7:59. She was in dark jeans, a gray coat, her hair was down. She saw me outside. She said, "You're early." I said, "I'm always early when something matters." She said, "I know." We sat at a corner table by the window. She said, "I want to have the full conversation, all of it. Not the version I gave you on the courthouse steps, which was accurate but partial. The full version." I said, "I'm listening." She said, "When you left in October, I understood it as a choice. Not because you were cruel about it, you weren't. But because the silence after was so complete that the only reading available to me was that you had decided the relationship was a cost you couldn't carry alongside everything else. And I accepted that reading because it was the one I had access to, and because accepting it was more survivable than the alternative." I said, "The alternative being?" She said, "That you were drowning and couldn't reach me, and I was on the other end of a phone you couldn't answer. That alternative was more painful because it meant there was something I could have done and didn't know to do." I said, "I should have answered at 7. She said, "You were drowning." I said, "Yes. But you were the person I should have been drowning in front of, and I chose to drown alone, and that choice, even though I didn't make it consciously, had consequences that were real, and that I am not going to ask you to treat as smaller than they are." She looked at the table, then at me. She said, "I want to say something, and I need you to let me say all of it before you respond." I said, "Okay." She said, "I have loved you badly. Not in the sense of loving you incorrectly or insufficiently, but in the sense of loving you in a way that has not served either of us well. I have spent 9 years converting something real into something manageable, a note in the file, a committee application, a policy about not using the applicant's name more than once. I have been very efficient about it. I have been extremely disciplined. And the efficiency has been a form of dishonesty that I am not proud of." She said, "I am not asking you to absorb the 9 years. I am asking only to say, I have loved you since the 3rd floor of the library, and I have not stopped, and I have managed that with a discipline that would have been better used elsewhere. And I am sorry that the managing was the only language I had for it for this long." I said nothing for a moment. I held what she had said the way you hold something that has weight and is exactly the right weight, not too heavy, not too light, the specific weight of something true. Then I said, "I have been in love with you since December. The 1st December. The night in the Carol when you said I would like to stop managing the, and I said okay, and you said, is that your answer? And I said, it's my opening argument." She said, "I remember that night." I said, "I made a promise I believed. And then I failed to keep it in the specific way that failing to keep promises happens, not through choosing to break it but through losing the capacity to hold it alongside everything else that was breaking. And I have spent 9 years wishing I had found the capacity." She said, "You're here now." I said, "I'm here now." She looked at me. I said quietly, "I would like to stop managing this." Her breath changed. I heard it, the specific sound of composure becoming something else, not cracking, not breaking, just rerouting, becoming foundation instead of wall. She said, "That's my line." I said, "I know. I've been holding it for 9 years." She reached across the table, not urgently, not with the fractured speed of someone who has been waiting too long and is suddenly released. She reached across the table with the patience of someone who has learned that reaching too fast breaks what you're reaching for, and she put her hand over mine. Her hand was warm, still. The same composure but directed inward now, holding the gesture rather than the distance. I turned my hand over. We sat like that at the corner table on Clement Street while the morning went on around us, and neither of us said anything for a while, because there was nothing that needed to be said that the contact wasn't already saying. I touched her jaw first, when she finally looked at me fully, warm skin, her breath, level but changed. Then I kissed her. It was not frantic. It was the opposite of frantic, the specific patience of something that had earned the right to take its time, that had gone through enough to know that speed was not the point, and arrival was. Patient, earned. The restraint finally becoming something honest, instead of something costly. When I pulled back, she looked at me the way she had looked at me on the roof, relief and recognition, in that specific order, in the space of half a second, like she had been given something she had not expected to receive, and the receiving was exactly what she had been trying to protect against, and the protection had not been worth what it cost. She said quietly, "That was." I said, "Yes." She said, "I'm going to need to revise several years of professional self-assessment." I said, "Take whatever time you need." She said, "You already used that line." I said, "It applies twice." The corner of her mouth. The full version. Not barely. The real one. The unmanaged one. The one that looked like herself. We stayed until the coffee shop began to fill the slow Saturday morning progression of people arriving with newspapers and laptops, and the particular ease of a morning that belongs to them. We talked about her partnership and the cases she found most meaningful, and the ones that had cost her the most. We talked about my mother, and the 3 years of caregiving, and what they had done to my understanding of time, and what things are worth spending it on. She told me about the year after I left, the way she had restructured it around the bar committee and the partnership application and the work, and how the restructuring had been useful and also a decision she recognized, in retrospect, as conversion. Taking one form of something and making it into another because the first form was not survivable. I said I was sorry. She said the work was real, the partnership is real. She is not mourning the year. I said I know, I'm sorry anyway. She said, accepted. It was the most specific form of grace she could have offered, and she offered it without ceremony. We left at 10. Outside on Clement Street, she stood with her hands in her pockets and looked at me with the composure that was real and the openness she had been allowing herself more of since the courthouse steps. She said, "I have a brief due on Monday." I said, "I know." She said, "That doesn't mean next Saturday is not also possible." I said, "I'll be at the same table at 8. She said, "I'll be there at 8:01. She looked at me for a moment, then she said, "Rowan." It was the first time she had used my name, without the context of examination, or professional event, or managed distance. Just my name, in the open air of a Saturday morning, without armor. I said, "Yes?" She said, "The next time you find yourself drowning, call me at 7. I said, "You stopped at 6. She said, "I know. I'm adjusting the number." She walked up Clement Street in the morning light, and I watched her go and thought about adjusting the number and the specific grace of that not forgiveness performed. Not the theatrical clean slate, just the real and specific offer to be reachable at a different point than before. Not more, not less, better. She argued a case before a panel of judges in December. I was in the gallery. Not because I was supposed to be there, because I wanted to see her argue without any of the professional distance I had been managing for 7 months. She was extraordinary in the way she was extraordinary at everything she had chosen to care about, precise, purposeful, each sentence doing the work it was supposed to do, and nothing extra. She found me after. In the corridor outside the courtroom. She said, "You were in the gallery." I said, "Row 4, left side." She said, "I saw you." I said, I know. She said, don't. I said, you first. She did something she had never done in any room I had watched her in. She put her hand to my face briefly. Once, the same care she brought to everything, and then she said, very quietly, thank you for coming back. I said, thank you for still being here. She said, I was always going to be here. I said, I know. She looked at me. For one long, open, fully present moment, Renata Ashford looked at me without managing what was in her face. Then she said, I have a client dinner at 7. I said, I know. She said, come home after. I said, yes. She walked toward the courthouse exit. At the door she turned just briefly, just enough, and looked at me across the corridor with the expression that was not the examiner's, and not the composed version, and not the managed professional warmth, but the real one, the December one, the one that looked like herself. It was the best thing I had seen in a very long time. I put my coat on and went out into the December city and thought about the roof in April and the library in December, and the 2 words in a corridor, and the hand on the table, and the specific patience of something that had taken 14 years to arrive, and had arrived exactly the way it was always going to, not dramatically, not cleanly, but honestly, with full knowledge of what it had cost, and full willingness to pay what was still outstanding. That, as it turned out, was enough. More than enough. It was the entire thing.